Welcome everyone to BDO's webinar designed for professional services firms. My name is Louis Keeping and I'm a tax director focused on advising professional services firms with over 18 years experience in the sector. And I've helped put together the webinar series for the past 10 years. I work with a broad range of professional services firms, generally assisting on a number of matters which range from compliance, reserves to international expansions, restructures, etc. So for today's webinar, we're providing an update on the latest employment tax and global employer space events relevant for PS firms. It's been quite a busy time for the global employer services advisors since the new tax initiatives were announced in the autumn statement. And some of the topics we're covering today are going to include obviously national insurance increases and potential mitigation strategies, national minimum wage considerations. It wouldn't be an employment tax update without an off-payroll labour update. A bit around the abolition of the non-dom tax status and FIG regime and how that interacts with globally mobile individuals. Changes to the Section 690 directives, a bit around non-resident directors, and then we'll do a piece on immigration considerations for employers. So for those of you who don't already know, BDO is the world's 5th largest accounting network, providing auditing, advisory and taxation services in over 165 countries. We've been long-standing advisors to the sector, and our national professional services team is one of the largest dedicated sector teams within a UK accountancy firm. Through our strong sector focus, we work with a full range of clients from boutique firms through to large international businesses, which include partnerships, privately owned corporates, listed and private equity-backed businesses. We've got a range of speakers today. They are Jackie Roberts. So Jackie is a director in the employment tax team with a focus on professional services. And I'm sure a number of the audience would have worked with Jackie before or know Jackie. Steph Carr. So Steph is ably standing in for Stuart Strong today, who's been struck down by a bit of an ailment and unable to present. Steph is the director in the Expat team, working with employers to help find practical solutions to the challenges presented by an ever-increasing internationally mobile workforce. And then finally, we've got Stephanie Fairclough. So Stephanie is an immigration advisor and alongside Immigration Compliance Services, helps businesses create workforce solutions in line with UK visa requirements. So as always, we are running this webinar live and encourage you to ask questions using the Q&A feature, which is at the top of your screen. We'll aim to pick up as many of the questions as we can at the end of the webinar, or if time does not permit, we'll come back to you after the session. We'll finish within the hour and share the slides and the link to the recording over the next few days. Over to you, Jackie.
Good morning, everyone, and thank you, Louis. Right, okay, so excuse me. I guess the key points from an employer perspective were previously set out in the budget, and there were no surprises with that legislation that was enacted in time for April, 6th of April. And they are as follows. I'm just going to whittle through those for a moment. So we've got the employer's national insurance increase from 13.8 to 15%. Not forgetting that also includes Class 1A national insurance for benefits in kind for 25-26 anyway, for the P11Ds. And Class 1B, which is on pay-as-you-earn settlement agreements. And just as a quick reminder, that's where the employer has agreed with HMRC to settle tax and national insurance on behalf of a number of employees for employee benefits. We've also had the decrease in the national insurance employer secondary threshold, which was the biggest shock, and that was reduced from 9,100 to 5,000. We know that for the current tax year going up to 27-28, that will remain the same, and then from then on will increase with CPI. The employment allowance, that was increased from 5,000 to 10,500. And for those on the call, you will probably be aware that the restriction for large businesses has been removed. So everyone is able to claim a small amount of employment allowance. We then had the national insurance. So we've got the national living wage for over 21s, a significant increase from 6.7% from £11.44 to £12.21. And sort of to put that into context, that's around 23,873 for a full-time working individual. And then you've got national minimum wage, which is 18 to 20-year-olds, and that's the biggest increase ever at 16.3%, going to a rate of £10 with a salary of around 9,500. And then you've got the apprentices and those that are 16 and 17-year-olds increasing to £7.55. So then the Spring Statement issued a raft of government consultations indicating a sort of more of a focus on compliance. And this includes the closing of promoter tax avoidance. And from an employment tax perspective, that could be where we're seeing there's going to be some changes coming next year on the umbrella company regime. We've also got an enhancement to HMRC's ability to tackle tax facilitation or non-compliance facilitated. And better use of new and improved third-party data. That would be a quite interesting one to see how HMRC use third-party information. And then some interesting consultation on the penalty position and getting that, I guess, in a more punitive manner, as well as I just mentioned about the umbrella companies. So of note for the employers will be focused on the compliance and HMRC's strategic focus on addressing that tax gap. So HMRC are intending to recruit 500 new compliance officers to increase tax collection and reduction in that tax gap, building on the earlier announcement of already 5,000 additional compliance staff. So we expect this to sort of trickle down to employer compliance and employer compliance officers being increased. And of course, that will mean employer compliance inquiries and campaigns will increase as well. Next,
I think from HMRC, Jackie, you do see the odd kind of nudge or approach around certain employment tax issues, and I assume that's going to continue to be the case given the recruitment of additional officers in this space from HMRC.
Absolutely, yeah. So there are nudge letters that have been issued in terms of off-payroll labour. We also know that there are nudge letters in the national minimum wage space as well. So yeah, absolutely. And I dare say there'll be more campaigns in the future. So what this has meant is obviously that's increased significantly employers' costs. So the measures are going to produce a difficult landscape for our professional services firms. The national insurance changes potentially represent up to a employer national insurance increase of £1,000 per individual on an average salary, that is. And what does this mean for employers, and what should we now focus on? So the actions we think could be split into sort of 3 key areas, and that will be employer governance, looking at how remuneration is structured and whether existing benefits are fit for purpose, and making sure personnel are kept up to date to ensure processes and policies keep up with the fast-moving landscape that changes. One of those is the payrolling benefits in kind. So employers really need to be fully prepared for mandatory payrolling of benefits, which comes in from April 26. And that means that income tax and Class 1A national insurance will be collected via the real-time information system. And businesses will need to report a lot more data to provide HMRC with a full breakdown of those benefits that are being processed, so that they can be checked, not just that they will be in the payroll, but the data that essentially might have been on a P11D will need to be included somehow. Low interest loans and living accommodation will only be voluntary from 26-27. I guess that's because of the complexities around that. But there will be published some information around that in the forthcoming period. And we also await special details regarding global mobility employees, as well as specifications from HMRC for software providers, because without this we are a bit stuck. So employers will need to sort of think about communications with employees so that they understand the changes. The biggest one will be regarding the fact that 2 benefits will be taxed in the first year, 26-27. And just as a reminder, that's because you'll have the benefit from the 25-26 tax year we're in now being collected in the same payroll as the 26-27 benefit being collected in real time. And I think lots of people haven't necessarily thought about that. And it's sort of key to making sure that employees understand that. So sort of managing their expectations there will be paramount. I guess it's not a case of just a simple exercise of dividing an annual benefit by 12 months. And it might be that a good idea would be to set up a focus group to assess the impact to your business and employees, and making sure that the calculation is correct by the time it gets to payroll. And we've been working with businesses to get them to understand what it is they have in their business and what they'll need to do for next year. And the process will need to capture all benefit changes in real time, such as things like starters, leavers, and also capturing changes in policies during the year. So I guess if you had medical insurance, for instance, if someone changed between individual to individual plus partner, that's something you're going to have to be able to amend in real time. There are complexities around some other benefits which haven't really been bottomed out just yet. And that's particularly regarding employees that might make good a benefit during the tax year or after the tax year. And what does that mean for payrolling? And also, pay as you earn can only be deducted up to 50% of a salary. And there might be cases where if you've got low salary but high benefits, that you will be unable to collect the tax because of a 50% overriding rule. So that's one to look out for. And awards by the business to employees of other employers, so third-party benefits. I mean, currently they're dealt with via a taxed award scheme, but now need to be captured in real time as part of the benefits through the payroll. And from our conversation with many today, employers are concerned about the logistics really, and whether they'll be able to meet the tighter timeframes, which could invariably lead to penalties in the future. And in terms of penalties, they haven't quite come to a conclusion as yet as how they will be sought. So that's payroll and benefits. Next slide, please. As Louis mentioned, we wouldn't be we wouldn't be here without talking about off-payroll labour, and there's a reason for that. It is high on HMRC's agenda. So mitigating risk requires the employer to have full visibility over their entire supply chain, and that includes the self-employed, personal service companies, agencies, as well as outsourced providers, because they're still providing a service and it's still something that needs to be looked at from a due diligence perspective. So HMRC would expect that there is sufficient due diligence to ensure that you've identified all individuals in a supply chain, and even if you're not paying them directly, were there to be PAY and NIC being deducted further down the chain, it's really good business practice for our businesses to ensure that they have evidence that that is captured. Of course, off-payroll labourer includes the having robust IR35 procedures in place. And this is not just purely an employment status assessment, which I think from conversations can be sort of like the tendency to think that is the case. But here we are 4 years on, and now HMRC have clearly explained in several of their publications that reasonable care is expected to be demonstrated in the end-to-end process. And that's when we're talking about all the way from identifying an individual through the process to payment. And of course, where that process falls down, there is the potential for up to 30% penalties in respect of the PAYE and national insurance liability. So therefore, I guess the key thing to do is to identify who is being engaged, how you're being engaged. Are you engaging an individual via a personal service company? Has the contract position already been agreed, considered? Does it need to be changed? Is there a PSC in the labour supply chain? And if yes, that's about the IR35 process. And robust documentation is required to evidence and support all tax decisions made, and that would include dealing with any appeals within the 45-day deadline and understanding the contractual supply chain and ensuring that you've involved people that are involved in the IR35 or off payroll process have that suitable training to know what they are doing in a compliant way. But if there isn't a PSC in the supply chain, you need to follow the other due diligences that I've mentioned. So evidence needs to be provided where HMRC have an inquiry, including outsourced service providers. The reason for that is because there's a tendency to say if you engage an entity that is providing sort of like a comprehensive service of individuals, but not just labour, then they would be outside of your remit for IR35. However, to be outside the remit of your IR35, you need to have evidenced that. So that's the latest that HMRC are saying. I guess really overall, employers are going to need to ensure that reasonable care has been taken in all aspects of that process. And it's quite possible that errors may arise, and therefore demonstrating reasonable care will mitigate the penalty position. It might be now the time to sort of consider some kind of reasonable care review undertaken by employment tax advisors to assess that you have all of the correct tax processes.
And Jackie, would this normally form some kind of policy or something like that around looking at your underlying status of individuals?
Yeah, absolutely. The policy would need to explain how a company goes about identifying who the individuals are, where they come from. Do they come from a business source, or do they come through HR or payroll or finance, etc., all the way through every single part of that process through to what do you do once they are assessed either as a deemed employee, i.e. have to go on the payroll, or if they are deemed self-employed, and the status assessment has to be issued to confirm that that is the correct process, and then of course they can be paid gross.
Okay.
Yeah. Next slide, please. I'm not going to spend much time on this one, though. I just thought I'd put it in there really to sort of leave you to digest once you get the slides, how quickly the numbers can rack up, particularly with our new 15% employers' national insurance. I guess the most thing of significance here is that there is now the potential set-off for corporation tax and dividend tax paid by the PSE, but it's a formal process that requires HMRC intervention. So if there is any errors, then HMRC will be looking at how and whether there is a possibility of that set off. Next slide, please. How am I doing for time? Okay. So for employers paying at the top rate of national minimum wage, the buffer for national I can't even say this today, national living wage and national minimum wage has been reducing, I guess, year on year. The reduction means that employers will need to be more vigilant in terms of ensuring compliance for those regulations. And we know that HMRC will review 100% of records when they come in and do a review, with employees earning up to 35,000, which is quite a high bar. And the reason for that is that employers are not necessarily getting it right on the more nuanced areas. So if you think about whether there is a non-compliant area, HMRC can go back 6 years for current and ex-workers. But more importantly, when they're calculating the rates at which you need to pay the individuals, it won't be the rate that they were due to be paid when the lower rate was paid. It's the current rate. And of course, we have to be aware that if there are errors, any errors at all, you are likely to end up on the public naming and shaming lists. In sort of like a roundabout number, excuse me, an underpayment in 2020 will now cost, with the penalties, up to 233.5% of that cost. So huge numbers. So what do we need to be thinking about from a professional services point of view? So employers need to record the number of hours that individuals are performing. So obviously that's not something that needs to be returned on an RTI. That was a discussion for this year, but actually that was cancelled. But in the absence of employers not recording the correct hours, HMRC will just go straight to worker testimony to collect that data. So you need to be thinking about hours for overtime, and also hours for sort of like study leave. This is one that we know that HMRC have been looking at, and perhaps for things like trainee solicitors, architects, apprentices, etc., where they are studying either at home or on site and it's part of a contractual arrangement, the likelihood is that those hours will be counted towards national minimum wage. We also have to think about, interestingly, because of a couple of national minimum wage cases, that deductions from net pay, so where an individual has voluntarily decided they want to purchase something, let's say in this case it was medical insurance, that can be excluded for national minimum wage purposes, or the pay before the deduction is what's used, is not used. It is the pay after the deduction that is used. And we all know that with salary sacrifice, that you have to exclude those as well. And finally, and I know this is going to be covered more by Stephanie, there's lots of clients we know in the professional services sector that have the sponsored worker license, and we are aware now that where there's an NMW or indeed a a VAT failure, and that was more recently, that there is the risk that the license can be revoked. So one to be aware of. We also know that HMRC are focusing on London businesses now. They've been going all around the country. There's Glasgow, Liverpool, Yorkshire, Midlands, etc. That have been targeted, and now we know that London is one of those. And HMRC are writing to businesses, but not just businesses, they're writing to the workers as well, highlighting common risks for national minimum wage and inviting worker complaints. So that's quite a tricky one. So next slide, please. So we've been talking about the difficulties for businesses with the increased costs, and what does that look like? I guess there are some studies out there that have showed that, and it's pretty obvious that businesses are going to have to be sort of thinking about what that means to them. Does it mean an increase in professional services fees? Does it mean staff restructures, reducing overheads? And then finally, what about mitigating the risks, and all while retaining, of course, good people? So another approach for professional services firms would be to consider what's offered in terms of benefits, such as pension salary sacrifice, green cars, workplace nursery. We know pension salary sacrifice, I'm not going to go into all the detail, I've done that before, but it's been available for years. We know it's approved by HMRC, and there's an employer saving that can be retained or shared, as well as the employee. So we've got a significant saving there. Green cars, if you are able to work with a fleet provider, there's significant savings if you compare that to personal leased cars. You can also get tax-free installation of charging points at home, which is something that employees have shown that they're interested in. And of course, that's a significant reduction on pay. So there's less PAY and NIC and a much lower benefit in kind charge. what you need to think about with things like that is the modelling and whether what the potential savings look like. And of course, I guess the main point about that is making sure that documentation is tax compliant and that you have comprehensive communications with employees so they can understand exactly what's happening in terms of salary sacrifice. Happy to talk more about that. And the final slide, please. Okay, I mentioned about workplace nurseries. This is an interesting one. So workplace nurseries has been something that's had a tax exemption for a long time. And the tax exemption applies to nurseries on an employer's premises and also third-party facilitated nurseries. Most businesses wouldn't necessarily want to think about putting a nursery on their own premises and running it and manage it themselves, but could, and that would provide a tax-free benefit. And with the average childcare now exceeding, I've sort of estimated this at around £18,000, it's eye-watering. We're seeing a massive increase in interest in this benefit. The benefit itself, once provided, is unlimited in terms of the tax exemption, so there's no cap. But if on this 18,000 example here, I've showed that the employee saving is over 7,500 a year, which is significant. Of course, the employer has a saving as well. So what that means is it's something that is of interest, and we have sort of third parties that are providing this facility. There are 4 tax conditions that need to be met, 3 of them being pretty simple. You need to have a qualifying child, so that will be a particular age range. There'll be qualifying nursery. Most nurseries will have Ofsted approved status, and that's easily found out. And the facility has to be available to all employees, or generally available, actually not to all, generally available. So these third parties, what they will do is they will work with the employer to help them effectively be involved in the management and finance of the nursery. And that's the 4th tax condition. It's quite a high bar, but of course the tax break is very high too. What you have to have is, because this is salary sacrifice, an individual at the employer would work as a representative with the third party intermediary and the nursery to help finance and manage the nursery. We've sort of said that's more akin to sort of like a NED role, sort of like go in, have an idea of what the process looks like, how much is going to be paid towards the nursery and what it's used for, and then leaving the nursery to then get on with actually running it on a day-to-day basis. There's a varying quality of arrangements out there, but some are really good, and we've looked at them. And we know that third parties are approaching businesses, and also because the employees know the massive tax break, the employees are also coming to the businesses to say, well, we would like to consider this. So a word of warning, you do need very careful implementation, quality paperwork, and of course robust salary sacrifice arrangements. However, the break is perhaps worth it and should be considered by businesses. So that is me, and I'm going to hand over to Steph.
Thank you, Jackie.
Thank you.
Thank you, Jackie. I was actually joking before this that I remember to unmute at least 50% of the time. So there we are, roughly 50%. So good morning, everybody. I am here, as Louis said earlier, in place of Stuart Strong, standing in for him today, to talk to you a little bit about global mobility, tax updates, where we're seeing interest from professional services clients, and an update on some legislative changes that could impact yourselves as businesses and representatives, and also your employees. So in terms of the things that I'm going to cover today, we'll look at the continuing and seemingly never-ending relevance of international remote working, also in terms of professional services organisations specifically. A quick look at the new, brand spanking new, as of a few weeks ago, foreign income and gains regime in the UK, which is the replacement for the old non-dom regime. The continuing focus also from HMRC on non-resident directors. And finally, a quick note on some of the interactions that we can see of special tax regimes for your internationally mobile people. So next slide, please. Oh, there we are already. So most of you will probably have some awareness already what we mean when we talk about international remote working. Essentially, it's enabling employees to work remotely from a different jurisdiction in which they are employed. And probably unsurprisingly, it's become a lot more prevalent since the COVID pandemic, and it's now seen by many as a key part of an employee proposition for attracting and retaining talent. As part of our BDO Workplace Evolution series throughout 2024, we were polling organisations across a number of different sectors, with results showing that 80% of attendees believed that the biggest change in the workplace was the expectation from employees for greater flexibility in their job. And 60% saying that their employers had adopted some sort of policy in the international remote working space to enable this. Interestingly, and perhaps a little worryingly alongside that stat, a huge 85% indicated that they still felt there was some way to go before they felt comfortable with those arrangements that had been put in place. And a lot of that comes down to the risk management concerns in this area. So, a couple noticed on the slide: corporation tax risks, employment law risks, cybersecurity. It covers a number of different areas. So next slide, please. So this one looks at some of the key areas and questions that we're discussing with professional services organisations, all of whom kind of see this introduction of a policy as an important step in order to attract and retain key talent, but might be at differing stages of development of that policy or the ongoing management of it. And the feedback that we hear from the sector is that there is certainly an appetite to offer greater flexibility. And then you move on to what is a very important discussion about what the potential barriers are to that policy, what parameters and boundaries do you want to put around that policy in order to manage it for all involved. So is that the length of time that you allow people to work remotely? Limitations on certain people, key people in the business, senior employees or partners working outside their home territory, restrictions on the types of things that they can do whilst working overseas, among others. And we find that the questions on the slide are really just a good starting point for what will inevitably be a very long, expansive conversation with stakeholders in the business, to start assessing some of the practical realities, but also the potential value to the business of that flexibility, alongside some of those risk parameters that will have to underpin the final decision-making process. So next slide, please. Thank you. So the final one here is really kind of more for information purposes than to go through in any detail here. But we know that with professional services clients, often the kind of overriding concern is around the permanent establishment risk that comes from allowing individuals, and particularly those senior employees and partners, the ability to work remotely overseas. And clearly there are many other concerns, almost a terrifying number of concerns, you might say, looking at this slide. But these are some of the most common. So we have the corporate tax, the immigration, which Stephanie will talk to you a bit about, data protection, income tax, payroll tax, social security, and a number of others. So lots of different areas to think about, and also that key point of who those stakeholders are in your business who might represent any and all of these different areas.
And it comes back to your initial point, though, Steph, doesn't it? We're still having lots of conversations around people grappling to understand where people are.
Yeah.
People are just working overseas in some circumstances without people knowing for a significant period of time until it's too late and you've tripped into permanent establishment penalties, etc., etc. And you touched on kind of policies again, similar to what Jackie did around her slides on employment tax perspective. But it remains, we're seeing a significant amount of conversations where people wanting something in place, where people are, as more people are asking, they've got definitive policy of this is what it looks like.
Yeah, absolutely. And, it's still something that you see in the public space a lot. Businesses advertising that they are fully remote, that they have a work from anywhere policy. And so that's why it becomes such a key part of your employee proposition, because the talent is saying, I could access this flexibility at XYZ different businesses. Why can't I do that with you? And so the concern is that businesses will fall behind in terms of that ability to attract and retain the best talent that they want to. But of course, it would be naive to say that it doesn't come with its potential issues, compliance requirements for the business. But it's kind of seeing that as an offset of maybe that's worth it if we feel like we have the best people doing the best things for the business. So next slide, please. So now I'm going to talk a little bit about some of these legislative updates, which, as a tax person, of course, I got very excited about. I'm sure everybody else wasn't having the Google alerts on latest finance bill updates, but that's what we're here for. So the finance bill from 2024-25, so from the last budget update, received its final royal assent on the 20th of March and came into force from 6th of April 2025. That included, from a personal tax and global mobility tax perspective, some very significant changes, including the abolition of the long-standing non-dom tax regime. So we don't really have the time in this session, unfortunately, to go through all of the changes in detail, but we've put some information on the slide for reference about the new regime, because it is likely that professional services organisations with diverse, likely international talent pools will have some staff impacted by these changes. At a very high level, the change in rules was aimed to make the regime somewhat less favourable to individuals coming into the UK who were living here for longer periods of time, while looking to retain some of the benefits that would be attractive to international talent coming to work in the UK for shorter periods of time, now up to 4 tax years. So historically, this period of favourable tax treatment could have gone on for as long as 15 years, so quite a significant reduction. HMRC have also removed the kind of key aspect of having to retain income and gains offshore from the UK in order to benefit from the tax relief, effectively to encourage those individuals to at least bring their money here and spend it in the UK economy. So in terms of direct impacts from the changes that could impact employers is partly that the reporting of foreign income and gains is likely to become far more onerous than it was previously for a larger pool of employees, and more complicated as a result of the changes, which is likely to have an increased cost implication for employees on assignment or those receiving tax support from their employer. Next slide, please. So overseas workday relief has also been changed alongside the new regime, with the important headlines that it's now available for 4 qualifying tax years in the UK to align it with the wider foreign income and gains regime, rather than the 3 tax years that it was previously. So hopefully a positive move in the right direction there. The requirement to structure bank accounts so that overseas income is received and retained offshore to benefit from the relief has now been removed, again in line with the wider FIG regime. And that should make arrangements and practicalities easier for both employers and employees. A final kind of relevant note is that the overseas workday relief benefit has also had a financial limit attached to it under the new rules, which was never historically the case, and that is relevant for each qualifying tax year. So a kind of assessment on a claim per tax year is now required, which also includes some extra kind of complexity from the fact that these employees may receive deferred types of income that cover multiple tax years, like bonuses or, share-related payments, for example. There are transitional arrangements in place for individuals who became UK resident prior to 6th of April 2025 when these new rules officially came into force. So it's also important to be aware that there might be slightly different implications for individuals who have arrived before or after the change in rules. Next slide, please. So finally, in terms of other important legislative updates, we have some changes to the Section 690 PAYE directive. So some of you may be familiar with this already. Essentially, it is a way for employers to reduce the proportion of an employee's income that is subject to pay-as-you-earn withholding through the payroll, if there is a basis to expect that ultimately only a proportion of their income will be subject to UK tax. So the circumstances usually where we would expect this to be possible is if the individual is not resident in the UK, so for at least part of the tax year, and that could be under the UK's domestic residence rules, or it could be under the terms of a double tax treaty, or otherwise somebody who is UK resident but is eligible for overseas workday relief, as we've just discussed. And for inbound individuals to the UK with an employer who might be tax equalised or tax protected, this can result in tax savings to the employer. So the main changes introduced are that the new online process enables employers to operate PAYE on that estimated percentage of UK taxable earnings from the point at which the application is acknowledged as received by HMRC. This is quite a welcome change because historically you had to formally wait until HMRC had received your application, put it in a long queue, processed the application, and then told you whether or not it was approved. So this is a significant improvement in that, and it's a movement towards more of a process now, check later approach from HMRC. So of course, they are reserving the right to look at these applications later or make any changes that they require. But from an employer compliance perspective, this is still a much better place to be. Another important change is that instead of being able to apply for multiple tax years at a time to be covered by a single Section 690 direction, a new application now is required every tax year, and the time frame in which to do that is much shorter in order to be compliant. So because of this more kind of real-time approach, the expectation from HMRC is that if you are implementing a Section 690 directive for a complete tax year, so from the beginning of April, this application should have been filed and acknowledged by HMRC before your first payroll run of the year. So that's an important point to note for future tax years, also for this tax year, if you are implementing any Section 690 directives in your payroll for April under a previously approved direction, some urgent action may be required. So that's an important thing to look at. HMRC have also confirmed that any Section 690s that were previously approved in respect of the now current tax year or future years that were issued prior to the start of this tax year will be considered to be invalid, and therefore a new application will need to be filed for the 2025-26 tax year in all cases. So that's a very important update. Next slide, please. So in the interest of time, I won't spend much time on this slide because it is an issue that's been around for quite a long time, and it relates more to a specific area of the professional services sector where you're structured with corporate entities. But at a very high level, HMRC are still interested in compliance in this area for non-resident directors, because it is seen as an area where businesses commonly make mistakes in the tax treatment and reporting. It is also an easy target for them because it tends to be based on publicly available information. So at Companies House, they can identify where there are statutory directors of companies listed who are non-resident in the UK, and it's a kind of easy target essentially at that point. So there is a bit more information on the slide. So just again, a note of caution on that one. So next slide, please. And this is my last one. So finally, I was just asked to cover some potential kind of oddities, I suppose, that can arise when cross-border employees might have access to certain preferential tax regimes in other countries. So, for example, in Spain, there is an expat tax regime that is commonly known as the Beckham law. So I'll let you guess and speculate where that might have come from. But it was designed to attract top-level talent and investment into Spain through offering a fixed tax rate of 24%, up to a certain level of income for expats working in Spain. And there have been a few issues that come up with individuals who have moved to Spain and used this preferential tax regime, which tend to be caused by the fact that individuals who are eligible for the Beckham rule are treated as being non-resident in Spain for tax purposes, even if they're living there, essentially the entire time. And that can lead to situations where ordinarily claims that might be possible under a double taxation agreement that Spain has with another country to exempt them from taxation in that place are not possible because they can't rely on the fact that they are treated as tax residents in Spain. So it's important that we're mindful of those kinds of interactions because it can cause some unexpected obligations for employers and employees, particularly where it relates to having work days in another location for small numbers of days that we might by default assume are not problematic, but in this case don't have that kind of underlying treaty protection that we might hope for. So
yeah,
we
sorry, just quickly on that, Steph, I think we've seen that on a few occasions on kind of our clients here as a firm. I think kind of there's similar regimes to the Beckham rule, I think, around the world, where the preferential tax treatment. I think kind of one of the issues raised is kind of as you're not resident, well, not actually resident in Spain, for example, you can't benefit from like short-term business visitor rules in the UK. So additional compliance burden. I think it's also kind of for other countries across the world where they're spending work days, as you mentioned. I think they may also have similar favourable regimes that they no longer benefit from. So it's something we spent a fair bit of time looking at and kind of has raised issues.
Yeah, exactly right. And, overall, there's probably still a benefit to these favourable tax regimes, but it's the awareness that it can come with some additional obligations. And many of those, particularly when it comes to work days, as you rightly point out, come with employer obligations as well as personal employee tax issues. So that is what we wanted to highlight here. But I will wrap up there and I will hand over to Stephanie to give you an all-important immigration update.
Thanks, Steph.
Hi. Yeah, thanks, Steph. Okay, I'm BDO's immigration advisor working within the industry for 12 years now. Next slide, please. I'm going to give you a very quick whistle-stop tour of the most topical things, I think, is probably the best way to describe it at the moment, of things that employers need to be aware of. And next slide. Okay, so we've noticed an increased scrutiny on individuals entering the UK as visitors. The UK Border Force is now checking whether the duration of a person's stay aligns with their stated purpose for visiting. So if you have overseas workers coming to the UK on a visitor visa, you need to make ensure their activities are permitted under that visa type. What is happening to the UK sponsor licenses the Home Office is reinforcing the idea that companies sponsoring foreign workers is a privilege and not a right. They're updating how they monitor companies with sponsor licenses to ensure the compliance, and for the first time they're beginning to work with other departments in the government to be updated on these changes, such as HMRC and Companies House. The Home Office allows for a company 20 working days to report any changes. If these changes are not reported within the time frame, the Home Office could take enforcement action, and that could result in the company losing the ability to sponsor any workers for at least 12 months. If a company's sponsor license is revoked, all workers under that license will no longer be able to work for the organisation, and they may need to leave the UK if they can't secure sponsorship from another employer. Next slide, please. Okay, short-term business visits. Many companies use short-term business visas as a way of sidestepping the need for sponsorship and the wider tax implications. Next slide, please. Okay. If a worker breaches their stay under the visitor visa, the several consequences may follow. The individual may face a ban on re-entering the UK. They may also face a ban of entering other countries which are aligned with the UK, depending on the circumstances of the consequences. It might be Australia is aligned with the UK, and so on. The company could be fined for employing workers without the right to work in the UK, and if the company holds a sponsor license, enforced action will be taken against the license. Next slide, please. Okay, sponsor license compliance. To bring you up to speed, here are two charts which are taken from the Home Office reporting on companies who hold a sponsor license. The chart on the left shows how many more companies now hold a license compared to 2020. There are many reasons for this, but predominantly it was due to Brexit, where companies who had many European workers had to suddenly get a sponsor license to continue employing those European workers. As a result, the increase of license applications, the Home Office are now cracking down on the compliance of those sponsor license holders. The number of skilled worker visas has been revoked in the last 2 years, has gone up by 6 times, and we envisage that number to grow even further this year. As Jackie said earlier, Home Office and HMRC are now really closing up the gaps in their practices and showing really joined up thinking in their approach. They're looking at businesses which use national minimum wage workers and will be prioritising those sponsors for compliance checks. Next slide, please. During 2024, the Home Office got rid of the requirement to reapply for a sponsor license. Instead, now licenses are granted indefinitely, which initially employers think, great, this is a positive step. However, in practice, it means that sponsor license holders may become compliant in their duties. And previously, it was fairly predictable when the Home Office was going to do a on-the-spot audit, usually before their license was due to expire and therefore be renewed, or at certain intervals throughout. So you as sponsors need to be taking a belt and braces approach to your reporting. Ownership changes in company type, like transitioning from a private limited company to a PLC or an LLP, company mergers, legal name changes, or one that does go under the radar a lot for people not knowing that it needs to be reported, is a relocation of registered offices. Next slide, please. So we have two areas of our sponsor license management. One, we have developed a system to monitor and protect our clients with valid sponsor licenses, ensuring you avoid any risks associated with not meeting your sponsor duties, namely surrounding business changes I just mentioned, but also those who predominantly use the national minimum wage route. Next slide, please. And our second strategy, we perform a mock audit. We guide you through exactly what the Home Office looks for in their own audits. And we do this by conducting spot checks, employee interviews, stress test your HR systems. I'll just skip over this slide quickly, but during that the practices on the screen are the 5 areas that we look at. And next slide. Following from, usually it's a whole, anything ranging from a day's up to a week's audit, we will then rate your practices in terms of opportunities to improve, important implementation, and essential and immediate action. Next slide, please. So what are we, or you as sponsors, looking out for? Business ownership changes, as I mentioned. If your company goes through any sort of ownership change, it is crucial to report that to the Home Office. VAT penalties. Now, this is a recent change to the policy. If a sponsor goes through a VAT penalty within the last 5 years, this can now be a reason for the Home Office to perform an audit and revoke the sponsor licence. We suspect this growing relationship with HMRC may lead to checks regarding other tax implications, such as payroll and income tax, as I think Steph and Jackie mentioned earlier. They will be checking to see if the income which are getting matches to the, are being matched to the income on the certificate of sponsorship to what they're getting paid in practice. And then we have offshore workers, national minimum wage issues, and confusion over the status of employees. Essentially, we need you to be asking yourselves, are your records tight? Because the Home Office is using increasingly joined up approaches to find vulnerable sponsors. Next slide, please. Oh, sorry, let me just finally recap before I mush it off. The Home Office has announced that companies employing workers within the gig economy now must legally confirm their eligibility to work in the UK. This means for the first time employment checks will cover the gig economy, such as 0 hours contracts. As it stands, we are waiting for the confirmation from UKVI to explicitly detail what those expectations are towards managing freelancers, but the feeling is that they will be covered under the same requirement to perform right to work checks as you would for your permanent employees. And super briefly, I know we're really stuck on time, right to work updates. Home Office has announced an extension to the grace period initially set in December 2024 for the e-visas to ensure there is no one disadvantaged, and the extension moved to the end date of the 1st of June. Individuals with biometric residence permits that expired on or after 31st of December 2024 can still use their expired documents for international travel until the 1st of June. Thank you.
Thank you, Stephanie. I think kind of it ties in quite nice, I think, with some of the work our team also does around kind of global expansion, looking at what structures to use overseas, and does that work from a visa perspective?
Yes.
And that can often be kind of we can go ahead and do a whole, that's what it looks like from structuring, but sometimes it doesn't even work from a visa perspective. So I think we also need to bear that in mind for when you're looking at
Yeah,
opening up
exactly
overseas.
right.
It's quite an important point. So I think we can offer all those services under one hat now, which is great. I'm just conscious of time, because obviously we've come to the end of the time. So thank you very much. We have had some questions from the audience that we'll pick up afterwards, because obviously tight for time now. So thank you to our GES and employment tax colleagues for joining us today. We'll share the slides and recording of this webinar in the coming days. Our next webinar is on the 3rd of June, which is a VAT update, and we hope you can join us then. And thank you again for your attendance, and wishing you a lovely day ahead.